What scope would the bill leave for someone to take a challenge to their removal? The individual challenge.
Great question. I mean, the first myth I talked about is the idea that the bill is there to challenge the authority of the Supreme Court. Well, there are some people who are very bullish on the Rwanda bill who believe it's completely watertight and bulletproofed against litigation. That's potentially not the case.
Right.
I think the legislation is intelligent. I think it's a consistent response to what the Supreme Court said, but it does not, although it does disapply aspects of the Human Rights Act, it does not disapply Section 4. So under Section 4, opponents of the Rwanda bill could make a complaint to one of the higher courts and say, listen, this is incompatible with the European Convention of Human Rights. Now, if the judges rule in favour of that, they can issue what's called a declaration of incompatibility, and Parliament can't ignore that because these are domestic courts, So that's one way in which the bill can be challenged. The second is obviously refers to Clause 4. Now, under Clause 4, asylum seekers can appeal their deportation to Rwanda. Now, if they say, I don't like Rwanda, it's not a safe country, then that's declared null and void, because generally speaking, Rwanda is a safe country. However, if an asylum seeker says, I acknowledge Rwanda is regarded as a safe country, but for me personally, due to my individual circumstances, I may be unsafe due to irreparable harm that may be caused, that claim has to be taken very, very seriously, and there has to be an evidence-gathering process. And there are two opinions on this. Individuals such as Robert Jenrick believe it may lead to a merry-go-round, an attrition of legal challenges, whereas the Prime Minister believes that actually Clause 4 applies to a very small number of cases. I think he cited medical grounds as one of the reasons. I'm not going to say which side is correct on this, but it does create an avenue for appeals to be lodged, to slow down the process. It's a logjam in the system. So the Rwanda bill, although it's an intelligent response to what the Supreme Court says, there are legal loopholes and avenues for litigation there.